Okay, I think we have quite a program today, so we should get started. Welcome to our webinar on the DSA, what digital intermediaries need to know. We're very happy to see that so many of you have dialed in, which shows huge interest in this topic. And at the same time, it shows us that the DSA has finally reached a broader international public perception, which is justified due to the great impact that the DSA is going to have in the future. Before we begin, we would like to briefly introduce ourselves. I'm Philipp Koehler. I'm a tech lawyer and salary partner at Taylor Wessing's Munich office.
Hi, and I'm Nathalie. I'm based in Berlin and I'm a senior associate at Taylor Wessing.
Hello, my name is Gregor Schmid. My practice focuses on technology, media, and data law, and I'm a partner in Taylor Wessing's Berlin office.
So let's take a look at the agenda of today's webinar. So we would like to give you an overview within the next hour on the DSA, discuss a selection of noteworthy challenges in practice, and also inform you about developments that have taken place in the meantime since the DSA came into force in November 2022. Feel free to ask questions at any time via the questions function that you should see in the interface. Obviously, we are glad to share these slides with you in the aftermath of this event. This event is recorded and will be published later on. And finally, we would also like to know a little bit more about your own take on the DSA. That's why we have inserted a few poll questions into the course of this webinar, where we would appreciate your input. With that being said, I think the first poll question should now pop up on your screen, and we would appreciate if you take a moment to answer the question. So I think we're set to go. Gregor, would you take the stage?
Yeah, thanks. Happy to do so. I think I need to click. Yeah, there we go. So we start very basic. We start with the question, what is the DSA all about? What's the fuss? Why is everybody posting news on LinkedIn and wherever? So I start very basic, and obviously we'll go into some more detail going forward. So the DSA, the Digital Services Act, was enacted on 19 October 2022 and has now become fully applicable across the EU on 17 February 2024, which was last Saturday. It has already been enforced for designated so-called very large online platforms and very large online search engines. Again, we'll come to that later on. Those are the very big players having more than 45 million recipients in the EU that were designated by the European Commission. So for them, the DSA has already been enforced. So what does the DSA do and aim to do? It's a very, very wide and sweeping law. It aims to set a EU-wide uniform new regulatory standard and a level playing field for digital intermediary services in the EU, and in order to adapt it to the current and future stage of digitization. As you probably, many of you know, we had a very basic law, which was the e-commerce directive in the year 2000, which set out some very basic rules for the digital age, but it was perceived as being too patchy and needing an uphaul. And also we saw the development of large digital intermediaries, online platforms. So the European Commission felt that it should act. To this end, the Digital Services Act aims to provide a safe digital environment, free from illegal content, to enhance transparency and accountability on the side of the service providers, to strengthen the protection of fundamental European and consumer rights, and also, quite important, to strengthen the enforcement, especially in cross-border situations. The DSA applies in a horizontal way, which means it's not limited to a specific industry, but it applies basically to all intermediaries as long as the definitions apply. It cuts across a number of areas. It touches several areas of the law. For example, consumer protection law, advertising law, questions of liability for illegal content, So areas which used to be in different laws are now also regulated in the DSA. The DSA has the approach of being a fully harmonized framework for digital services. However, of course, there are other EU laws regulating other aspects of digital services, of intermediaries. And in that regard, it needs to be taken into account that there are also other laws. And the DSA states expressly that it is without prejudice to such other laws that regulate other aspects of intermediary services in the EU. Examples would be data protection law. GDPR remains mainly unaffected. Also, certain aspects or many aspects of copyright law will remain unaffected. So as we saw what it's all about on a very, very abstract level, let's look at who is affected by the Digital Services Act. Who does it apply to? So the DSA applies to B2B and B2C providers of digital intermediary services, also referred to as intermediaries, who basically provide users and recipients with access to goods, services, or content. This includes providers of so-called mere conduit services. We used to call them access providers normally. This includes internet exchange points, wireless access points, VPNs, DNS services, and so on. It also includes caching services like content delivery networks, reverse proxies, and the like. And also, very importantly, hosting services, which many of you will already know the definition from the e-commerce directive, such as cloud computing, web hosting, etc. And as a specific form of hosting services, the wide field of online platforms, which includes social networks such as Facebook. And finally, and importantly, it also extends to online search engines. I don't need to name them for you. Now, we see this is an important distinction which is sort of carried through, as Philipp will explain, and it leads to different areas of regulation. But it is important to note that different services of one provider may be covered by different sections of the DSA. So one service or one part of the service may qualify as an access service or a conduit, while another may be an online platform, so different rules may apply. Having said that, we often being asked by clients, well, does it apply to me because I'm based in India or Turkey or the US? I'm not based in the European Union, so does it apply to me? So let's look at the territorial scope. Basically, not looking at this slide, you would probably say, whenever you have anything to do online with the EU, it probably applies to you. You need to take a look. In more detail, the DSA affects providers if they have an establishment in the EU. That's quite obvious. If they have a company here, if they are based here, or, and that's the other part, if they have another so-called substantial connection to the EU. Now, what does that mean? That means a substantial connection is inter alia given when the respective provider has a significant number of users or recipients in one or more EU member states in relation to their population. There is no absolute number given in the Act, so we will see how that is interpreted going forward. Or if the provider targets its activity, the intermediary targets the activities towards one or more EU member states. Indicators for such a targeting or substantial connection can be, for example, language, currency. For example, if you're able to pay in euros, a top-level domain of an EU member state, the possibility, of course, to order products or services from the EU, or local advertising or local customer services, which is explained in the recital to the DSA. In contrast, and there you see the exception is fairly small, the mere technical accessibility of a website alone does not suffice. So if there's a website in another language, which is not an EU language, you cannot order any services, you cannot pay in your local currency, you can only access it. So that would be a case where it is probably not applicable. And with that, I would like to pass on to Philipp.
Yeah, let's take a peek at the structure of the DSA, which is set up as a tiered regulatory system. So in a nutshell, the system provides general duties that apply to all intermediary services that are complemented by additional special duties whose applicability and scope depend on the categorization of the particular service. So the thing is, a certain service category must not only comply with the special duties of its own category, but also where available with the special duties of its upstream categories. When you take a look at the diagram here, you see that the lowest duties under the DSA apply to intermediary services because they only must comply with the general duties of the DSA. The lowest special duties apply to hosting services, which must comply with the general duties for intermediary services and the special duties for hosting services. Online platforms, in turn, are subject to further special duties. Apart from the general duties for intermediary services, they must comply with the special duties for hosting services and for online platforms. And the most extensive special duties apply to very large online platforms, which have to comply with the general duties for intermediary services, the special duties for hosting services, online platforms, and very large online platforms. When you consider the duties for very large online search engines, it has to be noted that the duties are unfortunately not completely consistent with this tiered regulatory system. The reason is that online search engines and very large online search engines were only added later in the legislative process, and the European legislator unfortunately did not establish a complete consistency with the tiered regulatory system. Overall, based on this structure, you can certainly understand that it's of significant importance to check out the categories in order to be able to determine the scope of the overall duties that are going to apply to your specific service under the DSA. Oh yeah, sorry, that was actually my take. This is just for completeness because, I mean, obviously we are only talking about the whole regulatory system on a very abstract level. So what we did just for completeness is put in a chart here, which sort of shows you the individual duties that are there under the DSA in connection with this tiered regulatory system.
Thank you, Philipp. And yes, finally for this chapter, we would also like to provide you a brief overview on the potential sanctions and claim under the DSA. So first, it's worth to mention that sanctions will be set out by specific rules of the EU member states. Therefore, the specific procedure will highly depend on the national law of the respective member state where the main establishment of the service provider is located. And this means also that the DSA also says that the competent authority to impose sanction will be the Digital Services Coordinator, also called the DSC, of each member state. Similar as for the GDPR, sanctions must be effective, dissuasive, proportionate in regard, in particular to the nature, gravity, recurrences, and duration of the infringement. And just to mention a few possible sanctions are, for example, the fines, penalty payments, and ultimately a temporary restriction of access to the service or online interface for users in case other measures have been exhausted and the infringement is continuing to cause serious harm and which entails criminal offenses involving a threat to life and the safety of persons. Such temporary restrictions, which initially can last for 4 weeks, are the last resort to stop the infringement. Then coming to the penalties, the DSA also includes fines, which probably does not surprise you. This is also generally the first question we receive, followed by the underlying scope of the regulation. So in comparison to the GDPR, EU legislators increased the amount of fines, which is now up to 6% of the service provider's annual worldwide turnover. And then last but not least, service providers may also face complaints from users of the service, organizations, or association alleging an infringement of the DSA as provided under the DSA. And users will also have a right to claim compensation under EU and national law from service providers regarding any damages or loss suffered due to an infringement. So this was an overview on the claims and sanctions. Now, with our next chapter, we would like to share with you the noteworthy challenges that we have seen during the implementation and compliance process coming up, and which you may face right now as well. So the following topics are not exhaustive and only a small selection that we thought may be commonly relevant for your service. So our first topic will cover the subject transparency, and in particular, the terms and conditions. So as you know, under Article 14, the terms and conditions shall include information on policies and procedures for content moderation purposes. This includes information such as policies setting out permissible and impermissible content online, also commonly known as community guidelines. Also, further reporting requirements, appeals procedures, measures and tools used for content moderation, and in particular, use of automated means such as filters. So the common challenges that we witnessed so far are, amongst others, the question around the level of detail and whether, for example, to provide specific descriptions of the policies and procedures, or whether to just include rather broad terms to ensure discretion in one or the other way. As of now, and in lack of any specific guidance, except for the Dutch regulator, the common practice appears to be to provide rather broad wording and link or direct users to a second page with further information. This also brings us to the second challenge, which we commonly face, is where to include such information. So, in light of the potential regulatory difficulties to change the terms and conditions under national law, for example, information requirements or even opt-in requirements, we have seen that such information is generally provided rather on the second page, directly linked from the terms and condition, than instead in the terms and conditions itself. Further, next comes the recommender system, which are systems used by online platforms to suggest or prioritize specific information to users in its online interface as a result of search initiated by the user. While compared to the terms and condition transparency requirement affects only or all service providers, the recommender system requirement only applies to providers on online platforms. So according to Article 27, online platforms are required to include information on the main parameters, including the most important criteria in determining the information suggested, the reasons for the respective importance, and where applicable, an option to modify the parameters. Similar as for the terms and condition, online platforms may face challenges regarding the level of detail and the location of the information. So we would refer to what we just said, to the terms and conditions. Further, we also faced some questions regarding whether there's a requirement to provide an option to modify the parameters on the online interface. However, we would say that in light of the wording of the DSA and the recitals, there is no such requirement. It only applies to those that offer already such options. So next transparency requirement on our slide are the ad disclosures. So similar as for the recommender system, the ad disclosure requirement only applies to online platforms. So according to the DSA, online platforms are required, amongst others, to label ads with prominent markings and to provide information on the advertiser, on the payer, and the main parameters on what you probably have seen so far, like why am I seeing this ad and how to change the parameters. And the common challenges that we've seen so far here are, for example, the definition of advertisement and the scope. What is considered ad? Is it just the classic ad, what we know so far, or does it also include sponsored content? Which we would regularly say yes. Then the disclosure for each ad, which may affect the customer experience and the design of the service. Then again, of course, the level of detail. Should the disclosure provide detailed information or just broad information? And then last but not least, also the placement of the disclosure on the online interface, which has to be clearly visible for an average informed user. So maybe in this course you have seen small information buttons where you can hover over and there are further information. So this seems to be the common practice right now. And I would like to give it to Philipp.
So the DSA generally has the challenge of being peppered with several vague legal terms, which often leave a lot of room for interpretation and thus deviating views. One of them is the wording on minor and purely auxiliary features or minor functionalities that are excluded from the definition of online platforms. Even though the European legislator has tried to explain the characteristics further in Recital 13 by explicitly stating that the comment section in an online newspaper falls within the exception, whereas the common functionality of a social network does not, sufficient legal clarity is not established. What remains unclear is what specific comment section of an online newspaper the European legislator had in mind. Scope-wise, there is no generally recognized standard, which brings up the question, what particular set of functions is still within scope of the exception and which are not? Does the exception only cover the most common functions, sharing, liking, disliking, commenting, and/or reporting infringements? Or does it also cover additional functions, such as accessing the user profile, which many comment sections of online newspapers do not offer? The obvious challenge will be to classify and attribute the many different layers and nuances that lie between the two examples given by the European legislator. One controversial example is the classification of a product review function in regular online shops. In all likelihood, this classification will be carried out on the backs of providers, as further guidance by the European Commission or competent authorities is not expected in the near future. For the time being, providers have the difficult choice between a low-risk and a risk-oriented approach, which both have their pros and cons. In this context, it should certainly be checked whether the provider qualifies as a small or medium-sized enterprise, because if that's the case, you are also excluded from the vast majority of stricter requirements for online platforms.
Yeah, coming up next is the notice and action mechanism. So under Article 16, this mechanism must be easily accessible, user-friendly, and allow a notice submission by electronic means. Regarding the form, the DSA provides that service providers shall allow to provide reasons for why users think content is considered illegal, then the name and email address of the reporter, the location of the content, for example, by providing a URL, and a statement confirming the bona fide belief. Following that, notice senders must receive a confirmation of receipt, of course, provided they include their name and email address to the service provider. And after taking the decisions, the content moderation decision, so whether to take down content or not, the reporter must be informed about the decision taken based on the notice. Additionally, but this only applies to online platforms, they must ensure to prioritize notices submitted by trusted flaggers. So the common challenges that we came across here with respect to the notice and action mechanism are, for example, where to locate the reporting button. Recital 50 of the DSA clarifies that the reporting tool should be located close to the information in question. However, does that mean that the button has to be right next to the content, or could it be, for example, a link or a button provided at the bottom of the page? Next challenge is also the question of what information should be required and versus only optional. In particular, This is relevant regarding the identity of the reporter. While Article 16 could be interpreted as requiring the contact information, Recital 50 clarifies that this is optional, except in cases of, for example, IP infringements and infringements of the personality right. Thus, where it might be necessary to determine whether the information in question constitute illegal content as claimed. Next would be the level of detail of the information notice provided to the reporter regarding the decision and possibilities of redress. So while the DSA does not provide any specific requirements regarding the content of the information provided to the user, compared, for example, to the statement of reasons, the information should allow the reporting user to effectively exercise their appeals right. Therefore, it should be arguably include some information such as the reasoning and grounds relying on for the decision taken to ensure some level of compliance. Then, regarding the trusted flaggers, online platforms must implement technical solutions in order to identify trusted flagger so they can prioritize their legal content reports. What we've seen so far is that this could be done, for example, by verifying those bodies through requesting their email addresses, and then check those against the publicly available lists, which will be provided by the DSCs of each member state or by the European Commission. Next, following the notice and action mechanism, we continue with the statement of reasons. So under the DSA, it is required to provide clear and specific statement of reasons for affected users following a restriction based on illegal content or incompatibility with the terms and conditions. So this means that the statement of reasons shall include, for example, the imposed restriction, including the scope and duration, the facts and circumstances relied upon, the legal ground and explanations of the reasons for taking this decision, and of course, information on the possibilities for redress. There are some exceptions which we wanted to point out, such as for deceptive high-volume commercial content published online by, for example, bots or fake accounts, and in case the service provider does not have the contact information of the affected users. Additionally, only for online platforms, they are required to also submit the statement of reasons to the DSA transparency database created by the European Commission. We will go into more detail in our next chapter on the current developments. Coming next, I want to follow up with the challenges. So the common questions we are facing here are again the necessary level of detail with respect to the explanation of the restriction, the specific reference to the legal and contractual ground, and whether it's just enough to state the section or whether it has to provide also the heading of the reference of the legal ground, and the information on the possibilities for redress, including the appeal right and, where applicable, out-of-court dispute settlement body and judicial redress under national law. And here it's questions that come up are whether it's enough to just provide a link or maybe further information. And again, this only applies for online platforms. Regarding the DSA transparency database, we've seen challenges regarding the onboarding process for this database and the technical implementation to submit statement of reasons to the European Commission. But we will also cover this in our next chapter on current developments.
So another challenge that providers of specifically B2C online marketplaces have to deal with is implementing the Know Your Business customer principle by taking the required measures to enable the tracing of traders acting on their marketplace. The main motive behind this is the DSA's overall aim to ensure a safe, predictable, and trustworthy online environment. The identification and traceability of traders is supposed to contribute to containing and tracking fake traders, legal products and services, and to better enable individuals to assert and enforce claims against traders. To this end, providers must obtain the following information from traders: name and contact details, whereby contact details means postal address, email address, and phone number, a copy of an identification document, payment account details, and where available, the commercial register number or any number of a similar public register. And finally, a self-certification by the trader that he or she complies with European Union law. A significant novelty under the DSA is that the provider has to verify such information for reliability and completeness via freely accessible databases and trustworthy documents provided by the traders. As you can see from the slide here, such efforts are limited by best efforts and solely contain a plausibility check. That means, after all, the trader stays solely responsible for the correctness of the data that he submits, but the provider can be made liable if he fails to comply with its verification duties. With respect to existing traders on the marketplace, the providers have to obtain such information within the next 12 months. What was widely criticized with respect to the traceability of traders is that there is no general causeless duty vis-a-vis the traders to keep trader information up to date, and there is no general causeless duty for providers to remind traders to update information when necessary. It has to be expected that there are going to be additional efforts on the provider side with respect to any restrictive measures that they take against traders, because those traders have the possibility to use redress options, in particular using the internal complaint handling system under the DSA and under the P2P regulation, as well as the out-of-court dispute settlement options under the DSA. Gregor, you're on mute.
Thanks, Philip. Sorry. I say a word on the calculation and publishing of average monthly active recipients. This is an obligation set down by Article 24, Para 2. So the DSA says that since 17th of February 2023, and at least every 6 months thereafter, online platforms and online search engines have to publish information on the average monthly active recipients of the service in the EU, which has to be calculated as an average over a period of past 6 months. This is a very important number because it will be taken into account by the European Commission when it decides to designate platforms as very large online platforms or a very large online search engine, so-called VLOP or VLOSI, the ones having 45 million or more average monthly active recipients in the EU. This is a bit of that was a very hot topic last year around this time of the year when the obligation arose, because the European Commission had not yet published any guidance at the time, at least not any complete guidance. So the question arose first, how to calculate it all, and what we can rely on is basically the recital number 77 and the guidance which I mentioned here, which was published roughly a year ago, which is a Q&A paper, by no means an exhaustive guideline. So what it means that there must have been at least one engagement in the given period, whereby viewing is actually seen as sufficient, except for online search engine, where there has to have been at least one active query. So you see it's a very low threshold. So of course, no double counting is necessary. So if you are able to identify double users or inauthentic users, such as created by bots or scrapers, you shouldn't count them, because that could artificially inflate the number. As mentioned, the delegated act, which should have been published by the European Commission, unfortunately has not yet been published, so we're still waiting for that. So when you arrive at the number, how do you publish it? It must be published in a publicly available part of the online interface, for example, your website or mobile app. app. And of course, if the European Commission or your digital service coordinator in your country requests it, you also have to provide it directly. I've given you just a few examples of a few platforms, how they do it. So to the left, you see Microsoft, an example. It's plainly available on the website. Information, average monthly active recipients. Here you've got Apple, the App Store, even broken down by countries. And this one is with a fairly high number, X, formerly known as Twitter.
Thank you. So next, we wanted to briefly point out the requirement to designate a legal representative in one of the EU member states where services are offered for service providers without an establishment in the EU. So the designation also entails to mandate the legal representative for being addressed by EU authorities regarding the receipt, the compliance with, and the enforcement of decisions relating to the DSA. The challenges that we face here is one, there is only a very limited choice of service providers offering the legal representative. This probably is caused by the risk of being personally liable in case of non-compliance of the service provider under the DSA. However, there are some available providers. So if you're interested and in need, please feel free to reach out and we're happy to provide or refer you to providers accordingly. Then second, additionally, we wanted to highlight the conscious decision that comes with the choice of legal representative and the place of establishment of the legal representative, because this mainly determines the competent digital service coordinator, so the competent authorities.
So you should have seen a vote. We're interested in the outcome. Let's see. Okay, so the outcome of the vote is the majority is apparently ambivalent. The question was, do you consider the DSA scope of due diligence and transparency duties to be appropriate? So 14% say no. Entirely, it's an overkill. 18% say yes, it's appropriate, but the clear majority of 68% says it's ambivalent, while some duties are comprehensible and appropriate, others do overshoot the mark. I would probably agree with that. All right, we wanted to look at a few more recent developments with you. And again, of course, this is not exhaustive, but ones which we found particularly interesting. So as you saw, the VLOPs and VLOPs have to be designated by the European Commission, and the Commission has become active. So the first bunch of VLOPs and VLOPs was designated on 25 April 2023. Some of them were kind of as suspected, including, for example, Twitter, ex-Twitter, which we've shown before. Others were not so obvious. And I would like to mention Zalando because that's public and they've actually started proceedings against their designation as a VLOP. They say we don't have 45 million average monthly recipients in the EU. So that's going to litigation. And also we have two search engines, not surprisingly, Google Search and Bing Search. And there was another designation decision on 20 December 2023. But this is by no means exhaustive, and it can the Commission can and will monitor this, as you saw, on this regular basis, whether it has to designate additional VLOPs or VLOPs. Now, this slide, we wanted to give you a look into what's actually happening in enforcement, because we often get the question, well, we see a lot of paper, a lot of obligations, there are fines, but does it really matter? Is it really being enforced? Because the background of this question, I assume, is that with GDPR, everyone was really nervous when 2018 came, and then before actual fines were issued, it took certainly a number of years. Now the fines are quite high, but the time wasn't, there was actually quite some time left to become, to get into line with GDPR. Now the question is it going to be enforced really fast? So spoiler is we don't really know. But I think the activity of the European Commission gives you an idea of that the Commission really takes this very serious and really wants to push it. So this is all public knowledge. You can look at this on the link, which is at the bottom of the slide. And we wanted to point out just a few ones. For example, App Store review. Some service providers have received inquiries by the European Commission about security measures in their app stores. Consumer protection, online trade marketplaces. The European Commission is asking some major online trading platforms to provide details of their efforts to assess risks, protect consumers, and prevent the sale of illegal products. Of course, these all relate to the VLOPs, to the big ones, because those were the only ones which last year were already in scope, already affected by the DSA. Protection of minors in social media. This is something also the European has voted to take very seriously. Accordingly, several major service providers have been asked by the Commission to provide information on the protection of minors. This also includes risks to users' mental and physical health, as well as the risk assessment and mitigation of such measures. Provision of data to researchers. That's also specific novelty created by the DSA. The Commission has sent requests for information to 17 VLOPs and VLOPs regarding information on the measures which they have taken to comply with the obligation to give access to the data that is publicly accessible on their online interface to eligible researchers. There's a specific provision in the Act that allows that. Content moderation. The European Commission has initiated proceeding against a very large social network regarding risk management, content moderation, dark patterns, advertising transparency, and data access for researchers. This is the one which has been very prominent in the news as well. And just yesterday, Monsieur Breton, who is very active on social media, said that he's now opened an investigation on his social network regarding alleged breach of transparency and obligations to protect minors. So I think this gives an indication that the Commission at least takes it serious. And as you will see, although some countries have not yet designated their national digital service coordinators on the national level, I think once they are designated, they will also take action. As I mentioned before, some designated VLOPs have challenged their designation as VLOPs by the European Commission, for example, Zalando. And if you want to dive deeper, feel free to reach out or look at the link which I provided at the bottom.
Now some insights on the implementing act regarding the transparency reporting. So the European Commission is currently working on an implementing act on the transparency reporting under Article 15 DSA. Accordingly, service providers are required to publish annually transparency reports on their content moderation practice. So the implementing act is aimed at increasing the quality and level of harmonization of the reports and to guarantee the same level of transparency and accountability across platforms. The adoption, as you can see on the slide, is expected for the first quarter of 2024. Therefore, we expect it by the end of March, the latest, but we also don't know. The current draft act includes the reporting template to be used by the service providers and an overview of the extensive information to be reflected in the report. In particular, amongst others, the report has to include the number of EU member states orders received and complied with, the median time which it took to comply and process it, the number of notices submitted, categorized by the type of alleged illegal content, including submitted by trusted flaggers, if you're an online platform, number and information on the content moderation engaged at service providers' own initiative. and also information on the use of automated means for the detection of illegal content and the decision taking, including the accuracy and error rate. The Implementing Act also sets out the first reporting period, which will be from 17 February until 31st December 2024. Following the next year, it will cover the whole year, meaning January 1st until December 31st. Reports must be published 2 months after the end of the reporting period in machine-readable format and in an easily accessible manner. We will provide you a link in the slides for more information on the status of implementation. Next, we would like to cover the DSA Transparency Database. As briefly mentioned on the Statement of Reasons slide, in September 2023, the European Commission published the DSA Transparency Database for online platforms to provide their Statement of Reasons submitted to affected users as set out under the DSA. By way of this database, the European Commission sets out specific categories of information required to submit, such as the content type, the date of application of the decision, the type of restriction put in place, the grounds relied upon, and the facts and circumstances around the choice of decision that was taken. The goal of the database is to enable more transparency and scrutiny over the content moderation decisions taken by the providers of online platform and to better monitor the spread of illegal and harmful content online. As this is fairly new and having received several questions so far, we wanted to briefly show you the registration and setup process. More information, of course, can be found online published by the European Commission. So regarding the setup, so it starts basically with registration on the DSA Transparency Database. And then the Digital Service Coordinator of the competent EU member state will reach out with details on how to onboard the online platform. This, however, may take a while since not every member state has appointed their Digital Service Coordinator yet. So following the onboarding, the online platforms will gain access to a sandbox environment to test the submission of Statement of Reasons. So the European Commission offers 2 technical solutions, either to submit the Statement of Reasons via an application programming interface, or also called an API, or a web form according to the volume of the data and the technical needs. As last but not least, after the completion of this test phase, online platforms will move to the production environment of the DSA Transparency Database, where Statement of Reasons can be then submitted via the API or the web form.
Yeah, I will say one on that, and you mentioned it, Nathalie, already. The Digital Services Act requires that every member state designates a Digital Services Coordinator, but this is the competent authority on the member state level that is primarily competent to supervise and enforce the DSA, whereas the Commission has a certain exclusivity as regards VLOPs and VLOCs. For all other intermediaries, the DSCs are in charge. There are also measures which provide for cross-border infringements, and there's a strong focus on cooperation and exchange of information between the digital services coordinators. Now, this is an overview. It should be more or less up to date by yesterday about the digital services coordinators for the different countries. And we, as you can see, some have already provided or designated them. For example, Austria, Czech Republic, Finland, no, sorry, not Finland, Italy, Portugal, Spain. Other countries, not notably Germany, but they've already sort of tentatively designated them there, but these laws are not yet final. So as you can see, the countries are a little bit behind when it comes to enforcing the DSA. We however think that this will happen within the next days, weeks, or at the latest months. I think, yeah, Philipp, over to you.
So another implementing act of the DSA that was just adopted at the end of last week by the European Commission is the one on Agora. I suppose this is at least nice to know for completeness, because it predominantly affects the regulators and not the businesses, but still it will come into force presumably within the next month, as it will be effective 20 days following its publication in the EU's official journal, which brings up the question, what is Agora? Agora is basically a communication platform and information sharing system for authorities, which has the aim to facilitate communication, cooperation, and information sharing between the digital services coordinators, the European Commission, the European Board for Digital Services, and other competent authorities that are involved. This communication aspect is likely the reason why the platform is called Agora, because Agora basically means public space in ancient Greek. Agora is supposed to be the backbone and an effective tool for the DSA implementation, especially the DSA supervision, investigation, enforcement, and monitoring. Against this background, it sets out the following main contents. So we have practically the stipulation of responsibilities of the digital services coordinators, the European Commission, and the European Board for Digital Services. We have a framework for access rights, which basically stipulate who has access to what kind of content. Then I think one additional important aspect is that Agora shall enable all member states to be able to read the documents on a need-to-know basis. So there are automated translation tools so that all documents are available in all official languages of the European Union. And at last, and that is also a major part of Agora, is a bunch of personal data aspects that justify the data processing of personal data by the different regulatory stakeholders.
Yeah, last but not least, also just for completeness, we also wanted to briefly point out that the European Commission adopted a delegated act in October 2023, mainly concerning VLOPs and VLOs. This act includes rules on independent audits to assess compliance of VLOPs and VLOs under the DSA. In particular, the rules provide details regarding the performance of audits, including the procedural steps and auditing methodology, as well as very insightful and helpful templates. Yes, and this is the end of our webinar.
Yeah, thank you very much. We would like to point you to one sub-site which we've created, where we've collected a number of publications on our website. Feel free to take a look at that one. Otherwise, I'd like the opportunity, if you guys are fine, to say just one word on dark patterns, because I saw it somewhere in the questions. Of what about dark patterns in the DSA? It's actually not specific. It's not only a DSA topic. Well, let's just say what are dark patterns? Dark patterns. Examples of dark patterns are website interfaces where you are, for example, nudged or misled to make a specific decision, for example, because some buttons are specifically highlighted, so you would feel closer to clicking those buttons, although maybe you didn't even want to. That's one example. Or, for example, if it's becoming very difficult to terminate a service, you ask for confirmation several times. So and this is something which a DSA covers in Article 25. So that's either deceptive or manipulative practices. So the DSA also contains a prohibition on dark patterns, although it doesn't call it dark patterns, but it's Article 25. In the DSA, however, dark patterns can also be an infringement of data protection law and unfair competition law. In data protection law, for example, they can be an infringement of the requirement of transparency or to obtain valid consent. And in unfair competition, unfair, and it's about unfair commercial practices. It could, for example, be a misleading practice or a so-called aggressive practice. So the DSA says in itself in Article 25, subsection 2, it actually says where it's actually GDPR infringement or an unfair competition, this shall prevail. So the DSA will only apply when the other parts do not, when the other laws do not apply. This is just a very brief summary of dark patterns. Philipp, you want to say a few words to the end?
Sure. Thank you for being with us. I see that we have still some additional questions, which are, I have to admit, quite specific. So please understand that we cannot at the moment provide answers to such specific questions, because this is rather, you know, a webinar that intends to provide you a general overview on the structure, the developments, and noteworthy challenges of the DSA. But we're happy to go into that when you contact us directly in the aftermath of this event. So thank you for being with us and checking out this webinar. And as Gregor mentioned, check out our subsite of the DSA, which is frequently updated with new topics on our website, because this is definitely the website where you will find a lot of different helpful information in context with implementing the DSA.